Everybody wants to know about the emails that Gina has alluded to saying that she has a cache of. A judge in this case is now referring this to mediation.
I've been in arbitrations that again have been just like trials and elaborate productions, weeks and weeks of preparation, and all kinds of pre-trial motions. Mediation is not arbitration.
Renegade Online. Disney Mandalorian actress Gina Carano taking firing suit to mediation. So there's a lot of questions that came out of this. This is from Bloomberg Law. So basically, Wednesday this week, a judge in this case that denied previously Disney's motion to dismiss said, I think there's enough here to just throw this case outright. Let's see where this goes. Is now referring this to mediation. So a lot of us have questions. What is mediation? Is this something that is commonplace in cases like this? What does this mean, potentially, one way or another, for the future of this case? So it just so happens that we have somebody that is a little skilled in this area of expertise. We're going to bring him in right now. Thank you for joining us once again. The great Ron Coleman is here. How you doing, Ron?
Good evening. Good evening, and welcome from. Thank you. No, please. No, please.
No, so we had this update this week. So let me read a little bit from the article here just to set it up for the audience.
Yeah, you do.
Disney and a former star of The Mandalorian will take the actor's protected speech lawsuit, which is supported by Elon Musk, to private mediation, according to a federal court order. Gina Carano and Disney were referred to private mediation on Wednesday by Judge Sherilyn Peace Garnett of the U.S. District Court for the Central District of California. The mediation must be completed by July 15th of next year, 2025, which would be prior to, as of right now, the scheduled start date of the trial, which would be September 29th of next year, 2025. So we're talking about a year away. Gina alleges Disney violated a California law that protects employees who are politically active outside of the workplace. We've covered this before. She said that alleges that Disney and Lucasfilm wrongfully cut her from The Mandalorian after she posted, as we have referred to it, as fairly innocuous content. Doesn't rise to the level, I thought, of being in any way what they claimed is anti-Semitic, which I thought was the most hilarious part of this. But we have now, to catch folks up, lawsuit was filed, basically, by Gina Carano. Disney filed for a motion to dismiss. This very same judge said that, no, I don't want to dismiss it out of hand. We want to go a little bit further. I'm interested. Let's hear more. Now, the judge has come back a few days ago and referred this to mediation. So, Ron, what is mediation?
Mediation is not arbitration. Arbitration is private. Let me just get a little centered here. Arbitration is private litigation. And one of the things, in fact, that people asked when we had this discussion, when we were talking about the case earlier, was, isn't it rather surprising that this dispute wasn't subject to mandatory arbitration in her contract? And that was a little bit surprising. Mm-hmm. But in any event, mediation is an attempt to settle, which is guided by a mediator. Mediators have all kinds of techniques that they use to bring parties together, to isolate issues, and they can be incredibly effective. What the judge did here was, I saw in the chat someone asked, Ron, was this mandatory? Yes, the judge did order mandatory mediation, but she also said that it had to be finished before next June.
Right.
That means that it may not actually be taking place in the foreseeable future. And it probably makes sense that it won't, because what the plaintiff is going to say, what Gina Carano is going to say, is that my ability to get an adequate settlement here depends on my getting discovery. Without discovery, I can't prove my case, which is that they actually fired me for reasons having to do with my political speech. So I want to get into discovery. And a very common approach that's taken at this juncture is, instead of going all the way through discovery, I said, everyone here has heard the term discovery, and I've got a video on my channel where I explain a little bit about what the discovery tools are. But there are basically two broad categories of discovery. One is what's called paper discovery, and one's depositions. A very common approach to dealing with a mediation order such as this one is to say, let's exchange paper discovery, which in a case like this is probably a 3 to 6 month job anyway. And then before depositions begin, that would be a good time to do the mediation. One of the main arguments for doing that in a normal case, the kind of cases that lawyers such as myself handle generally, is you save a lot of money. Depositions are where things very frequently start to really ramp up in cost. This is not what you would call a major documents case.
Mm-hmm.
There are going to be documents, and there are going to be issues with privilege and that sort of thing. But this is not a toxic tort case. We're not going back into corporate vaults, that kind of thing.
Mm-hmm.
So paper discovery should actually be fairly manageable. The problem is, if you don't get any discovery, you basically end up in the same exact position you were in before the lawsuit. I say yes, you say no, and neither side has much of an incentive. Okay, so Disney will say, sure, we lost the motion to dismiss, but you've got nothing.
Mm-hmm.
Now, she might have more than nothing. We don't know exactly what proof Gina actually has that people have provided her with, but what she wants is the stuff that she doesn't have. So what I think we will see is that discovery will proceed probably through the rest of the year.
Mm-hmm.
And then sometime early next year, there will be and this is, mediations are usually 1 or 2 day affairs. I have never heard of a mediation going much longer than a couple of days.
The preparation obviously might take a long time, but the actual event itself, you're saying, is what might take a couple of days.
Yes. I've been in arbitrations that, again, have been just like trials, and elaborate productions, and weeks and weeks of preparation, and all kinds of pre-trial motions. Mediation is usually much more efficient. What the mediator will usually do is say, I want a 5-page mediation statement from each side. And you can attach a certain amount of evidence to that, or not. You're not, the thing to understand is that the mediation statement is meant to give the mediator a sense of what each side believes is its best case.
Mm-hmm.
And he'll also ask for a settlement position. What are you looking for?
So do we know who the mediator is, and how is that selected, Ron?
In most courts, there is a panel of mediators that the parties are, as a matter of first recourse, recommended to consider. And these include distinguished private mediators, many of whom are former judges, and all of whom have been trained in mediation. And again, someone once recommended to me that I might find mediation to be a nice approach to my career, to adding that on. And my problem with mediation, as a mediator, acting as a mediator, is that they have to employ these. They're almost like used car salesmen or new car salesmen. Like they'll say they do these breakout sessions. I mean, there's usually an introductory session. Some mediators skip the breakout, the introductory session, because they don't really usually accomplish anything, and sometimes they just reinforce bad feelings.
Mm-hmm.
And then there'll be a breakout session, and most of the time the mediator meets first with the party that he believes, based on the pre-mediation submissions, that is most likely to need to be beat up and to be brought. But whatever is shared during mediation
Mm-hmm.
is confidential, unless one party authorizes the mediator to disclose it to the other side for purposes of achieving a settlement.
Mm-hmm.
But it also cannot be used in the litigation. It's
Okay,
not
so
admissible.
that's
Very
what I was.
important.
That's one of the things I was going to ask. So the purpose of this, and this is to try to, I think, like you said, it sounds like to try to reach some type of agreement or consensus, or maybe work this out before it goes to a full trial, so they can show up and say, Your Honor, we've resolved our differences, we've come to a settlement, it's going to be private, and okay, moving on. So just to be clear, though, during mediation, it sounds like you're saying there is maybe not the same thing as a regular trial, but there is some sort of a discovery event there, obviously, at least to the mediator, but that the evidence. So, for example, let's cut the crap on this one. Everybody wants to know about the emails that Gina has alluded to saying that she has a cache of, right? Between herself, people at the Walt Disney Company, people at Lucasfilm, and that could be Kathleen Kennedy herself. That could be Jon Favreau, who was there, Dave Filoni, Pablo Hidalgo, Carrie Beck. I mean, throwing names out there, but these were names that came up in the lawsuit. Okay? Maybe some inter-office emails between her and Pedro Pascal. We don't know. But she's got a cache of emails where she was claiming, I've got proof that I was being bullied and harassed incessantly while all this was going on, and I wasn't going to just take it, and I wasn't going to do what they wanted me to do, and they fired me for it. They terminated Cara Dune as a character in Star Wars, who was going to have her own TV show and all this other stuff. If she were to share those emails with the mediator that her legal team and Disney's legal team would, in theory, have to agree on, that's not going to be made public. And
Correct.
however, if it goes to trial, if it goes to trial, I'm assuming they would re-enter that as evidence, or would that carry over from the mediation, or is it just what is it that's held private in the mediation from the actual trial were it to go to
The
that?
mediation is basically an island in time.
Okay.
Nothing that happens in the mediation has any effect on the trial, except the experience. And in other words, sometimes parties will agree to mediation, even when there's a high degree of confidence that a settlement is impossible, because it will provide some insight into the other side's position. But evidence is not part of that. And I want to make it clear that any evidence that is used in mediation, again, the only reason you would use evidence is to let's say a mediator comes into your breakout session and says, like, I just spoke to the defendants, and they say there's no way Gina could possibly prove that she was fired because of the thing that she said about Donald Trump, because we didn't even know that she had any interest in politics. So then you say to the mediator, well, actually, we've got binders here of the evidence that has been exchanged in discovery, and here are 5 emails, and here are 4 tweets, and here's a memo, or whatever the case may be. Don't let them snell you. Now, remember, the mediator is not making the decision. He's trying to bring the sides closer. As someone pointed out in the comments before my computer froze, the mediators really, really lean. I mean, it's really a point of pride, and some of them get massive hourly rates because they're really great at this. To settle cases that both sides thought were impossible to settle. One of the advantages of settling the case, besides the saving the money and being in control, and by the way, one of the lectures the mediators inevitably give is, if we settle this, you're both going to be in control of what the outcome is.
Mm-hmm.
But if you don't, Gina, you could get nothing. Disney, this could blow you up in terms of public relations. You got exposed to a jury. That's part of the, that's part of the spiel that they give. But if the mediation fails, and presuming that they do the mediation after paper discovery is exchanged, then they merely go into depositions, and they can't say, "Isn't it true that we had a mediation, and your position was that you would, Ms. Carano, that you would take $10 million to settle this case?" That's completely off limits. But if there's no settlement as a result of the mediation, they just go right ahead toward the trial date. And you were asking, Valiant, when does the public get to see evidence?
Mm-hmm.
So the only time the public will see evidence until a trial is in the event that there is a motion.
Mm-hmm.
Motions may be accompanied by evidentiary submissions. The most extensive motion is a motion for summary judgment, which is not supposed to be the judge trying the case on paper, but looks a lot like that.
Mm-hmm.
And in that case, each side, it could be one side or it could be both sides. But in cases like this, it's typical that both sides will make cross motions for summary judgment, in which each will argue they have failed in discovery to come up with enough damaging stuff on us to even bother going to trial. Judge, this is a case you can handle. Jury doesn't have to be sworn in for this. So that's a summary judgment motion. And if it goes to that point, that's when a lot of stuff is going to get into the public record.
Mm-hmm.
But before the summary judgment motion, there could be discovery motions. So one side might say, we refuse to give you this category of documents because it's not reasonably calculated to lead to the discovery of admissible evidence. It's irrelevant. It's harassing. So the other side says, here's why you're wrong. And part of the reason I might be able to convince the judge that you're wrong is by attaching evidence that's already in the case that points in the direction of how the stuff that I'm looking for will enhance my ability to get admissible evidence. So as motion practice, as it's called, as discovery motions play out, and then a summary judgment motion, and then possibly what are called motions in limine, which means motions that involve what evidence will or will not be permitted ahead of trial. That's when the juicy stuff comes out. In the event, even if there's no trial, the closer you get to trial, the more evidence comes out. Now, let me just make a final point in terms of trial and evidence. One of the cards that Gina holds, and she, I imagine, has mixed feelings about this, is that by settling, she gets Disney off the hook on having their internal communications shared.
Mm-hmm.
It's a card that is more valuable before it's played than once it's played. In other words, if her position is going to be this information I demand that this information come out, and I want to go to trial. Once it's out, you can't unring that bell. You can't take, whatever comes out will come out. And we talked, I think, a couple times ago about what, protective order that may or may not be entered in this case. It's only going to protect proprietary information, not the stuff that we're really curious about here in all probability. So that's going to be one of the parameters that affects settlement here.
Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.